All right, perfect timing. Let's head back to the courtroom now. The defense closing argument in Ohio just getting underway. Let's watch.
The defense doesn't give an opening statement when you have no idea of what a 25-year-old lying charlatan might actually say to you folks. It's easy to give an opening statement when you have power and control of the state's alleged ear witness and named eyewitness. May it please the court, Judge Conway, opposing counsel, members of the jury. Changing the death certificate, giving complete immunity to someone who duped the police by their own admission, lied to them repeatedly, taking pictures and reinvestigating this case less than 1 month ago on November 25th, 2025. Now, there was a movie a few years ago, and the line was, if you ain't first, you're last. Well, good old Ricky Bobby wasn't talking about a criminal proceeding. He was talking about racing cars. Revving up, let them go. Because in a criminal proceeding, the government gets to go first and last. So what does that mean? This is the last chance I get to talk to you. I'm sure that might make some of you happy. But it's what I'm going to suggest to you in a case like this. It's the quality of what I tell you, not quantity. Just like in a case, it's the quality of the evidence or not the quantity of irrelevant stuff that means nothing. Now, I want to talk to you about the levels of proof, and we talked a little bit about this in voir dire, and it's important. Think of this as a ladder. To find Paul guilty, you have to find him guilty beyond a reasonable doubt, the absolute highest standard in our legal system. Reasonable suspicion is a term that's used. That's when the police are allowed to engage you because they think something might be up. Somebody's acting shady, they can approach them, ask them what you're doing. Is there an open container, whatever. They have reasonable suspicion that what we call criminal activity is afloat. Means nothing in this case. Probable cause is the amount of evidence that an officer needs to arrest someone. That's it. Could be one person saying, hey, that guy just took my wallet. Can't prove a negative. Preponderance. That's the amount of evidence you need in a civil case. It's more likely than not. You can have $1 million verdicts if the plaintiff, in this case, the plaintiff is the state of Ohio, but in the civil case, it could be somebody suing for a myriad of things. But preponderance of the evidence means they only have to show it's more likely than not. 50.00001%, if you will. Clear and convincing evidence. The government feels a child's in danger. For them to come in and take the child away from mom and dad, they need to establish before a judge the clear and convincing evidence. Finally, proof beyond a reasonable doubt. Proof beyond logical doubt. Well, here we go again. Ken, are you on there or what? Nope. Okie dokie. See if I can go old school. What I did was working just 5 minutes ago. All right. I wish I had the edges stitch, remember those things? Those are great, you know. Then I kind of shake it up and spend a little time getting it back out. Judge is going to tell you. The indictment informs the defendant that he's been charged with an offense or offenses. The fact that it was filed may not be considered for any other purpose. And it's important, like we talked about in voir dire, because one of the first things I asked you at the panel was when you walked in that door for the first time and you saw me and Paul sitting over there and you found out he was the defendant and I was the lawyer, I asked you, did you ask yourself, gee, I wonder what he didn't do? And most of you all of you said, no, man, I never thought of it that way. But that's the presumption of innocence. And so a lot of times we have people think that just because somebody's charged, oh, the police must have this great case against them, they're not going to waste all this time and energy. Wrong. False. You have to be arranged. Mr. Sigley touched on these, just like levels of proof in our system. This is what we call mea culpa. We got all these fancy words. But really what it means is thought process of the person that's accused with the crime. And purposely is the highest that you can go. And we'll get to it. I'll try to show you some distinctions. Knowingly and then recklessly. There's also negligently. And although Mr. Sitterly talked about negligence and it came out a couple of times, there's not going to be any charge that actually, we're not saying in any way, shape, or form that there was a negligent homicide here. And I'll eventually argue to you, I believe even if you believed all the state's evidence in this case, the most you would be able to logically find would be that the defendant acted recklessly. And that's if you believe their whole case. Okay, a person acts purposely. This is important. Purposely. When it is the person's specific intention to cause a certain result. Let me give you some examples of purpose.
Or the defense's closing argument in the Paul Hicks case and the sentencing for Mia Bailey expected next hour. She pled guilty for killing her parents. Stay with us. You're watching Court TV. Your front row seat to justice.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott in today for Ted Rowlands. We are in Ohio this afternoon where the fate of Paul Hicks will soon be in the hands of that jury. Nearly 25 years ago, Paul Hicks' wife, Regina Hicks, was found dead in her car at the bottom of a pond. Now, investigators suspected Hicks from the very beginning, but they didn't have enough evidence until now to charge him for the murder. A key witness is Steve Gates. Now, he testified during trial that he witnessed Hicks putting his wife in the passenger seat, she was unconscious, of her car and then driving it into the lake. But will that be enough to convict Hicks in this nearly century-old cold case? Well, we're going to find out soon. For now, here's what we want to do. We want to head back into court for more of the closing arguments.
Let me give you some examples of purposeful murders. You take a firearm and you point it at somebody's head point blank and you pull the trigger. There is no doubt, there is no logical doubt that you intended to purposely kill that person, right? Your conduct was purposeful, killing you. Or the alternative, if you shoot a person several times, center mass, that would be good evidence that the person intended to kill that person. Okay? Knowingly. A person acts knowingly when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. And the judge is going to give you these instructions. I assure you I'm not making this stuff up. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. Okay. Not being careful enough, beyond negligence. And then a person acts negligently when, because of a substantial lapse from due care, the person fails to perceive or avoid a risk that the person's conduct may cause a certain result or may be of a certain nature. So let me give you an example. Like in a negligent homicide case, let's say a person goes left to center and they strike somebody head on and they're killed. That would be negligence, okay? Now, if they were drunk or high and they went left to center, that would be reckless homicide, okay? It would be what, actually, excuse me, misspoke, would be called aggravated vehicular homicide because it's deemed reckless if you're driving, cause serious injury or kill somebody while you're under the influence. All right. Now I want to address some of Mr. Sitterly's arguments. Now remember, this is the last time I get to talk to you, so when Mr. Caceres gets up here, I want you to think in your back of the head, well, what would the defense say? Okay? First and foremost, the opening statement, the opening remarks in closing argument by Mr. Sitterly, their whole case is based upon speculation and conjecture and hoping that you're going to take a great leap and latch on to the testimony of Steve Gates. Now, I want you to think about this. They charged 3 counts of murder because they don't know what or which murder it was. They can't rule out elements of each of the murders. They've had 25 years, a quarter century, to figure out what their theory of the case is, and they haven't done it. So they're going to tell you people that have heard from all these strangers, seen all this stuff, you go back into that room and you tell us what you think. Okay? We can't prove our case, so what we're going to do is we're going to tell you what a bad guy Paul is. Some of the stupid stuff he's said. Some of the mean or, not so nice stuff he said. But guess what? That doesn't go to the elements of the offense. It doesn't go to the elements of the offense. You're not here to like Paul. You're not here to dislike Paul. Yeah, respectfully submit, the duty is to hold the government to their standard of proof. We've heard this a couple of times, consistent with, from some of the experts. And we had several experts, and if you'll recall, there's only one that I objected to, and the judge agreed, and we'll get to that. But consistent with. I'm going to tell you, I believe the evidence in this case will show that Steve Gates has been consistent with himself for 25 years. What do they mean when they say consistent with? See, it sounds scientific. Well, it's consistent with. That's like you or I talking to each other in a bar or somewhere. That's what it really means is, it is what it is. That's what it means. We've heard that phrase before, right? It is what it is. It's consistent with. So let me give you an example. Let's say the tire tracks in the case were the issue for the jury to decide, that it was a key fact in the case. And the expert says, well, it was consistent with the tires on a 1994 Camaro, or it was consistent with the tires on that car. Yeah, it was also consistent with the 2 million other tires that are driving around with those tread marks. That's what consistence means. It's not ruling out that, and a lot of them testify to that. They can't rule it out. They can't rule things out. They talked about the fingertip injuries that Mr. Sewey did in his beginning and closing argument. And once again, I think I asked the doctor, right? Hey, did you determine whose? Did you check hands? Did you check the hands of Steve Gates? Did you check the hands of the other suspects? He's 6'7". He's like Lurch. I mean, they told you that Steve Gates was interviewed 6 different times. What did he tell you? I've been interviewed several times. And guess what? Going back to October 2001. That's our lone exhibit. It's his written statement. And the reason it's important is he's been Steve Gates from that time. Not truthful. Not only do the experts say consistent with, and I hope you understand a little bit better now, Mr. Stitterly said, he talked to you about, first of all, he talked about digging a pond. That's come up a couple different times. There should be no dispute that they were apparently digging a pond, at least if you believe Steve's testimony and the testimony in the case, they're digging a pond there. There was mud there, and we'll get to that. But Mr. Stitterly says, in the car entering the pond, well, it seems to be consistent. That's a problem. That's a total admission of reasonable doubt. Logical doubt. Talk to you a little bit about that the defendant didn't act or conduct himself accidentally or recklessly. Well, the problem is 1 or 2 of their witnesses conceded to me, well, yeah, I can't rule out that it was something accidental happened. I can't rule out that it was reckless, that the defendant acted with heedless indifference to the potential consequences. Then he talks about Robin Fitz. One of the more entertaining witnesses I would submit in this trial, right? But it's bar talk, okay? We know that the parties are separated. He has a girlfriend. We know she has boyfriends. Okay? He's dating Jansen. He's yucking it up with her mom, okay? But once again, whether any little snippet they can get to make him look bad, they'll use. He talked about this twin brother. There's no evidence that he ever said, well, I have a twin brother and he did this, or I know he did this. That's ridiculous. And we'll talk about deliberations a little bit later. But when you go into those deliberations, they ask you to remember all that stuff. Collectively try to remember. Listen to each other, okay? A jury's better than the sum of their parts. They're bigger than the sum of their parts. Now, actually, I thought of that during the trial. Robin Fitz. Remember back in the 70s or 80s with the Where's the Beef commercials? Where's the beef? Where's the beef? The lady from, Columbus, Women's, thought that they ought to call her. But let's get to the beef in the case. Zero forensic evidence linking Paul to the alleged crime scenes. Zero. Nothing. More importantly, far more importantly, zero forensic evidence to corroborate the scientifically unverified fiction of charlatan Gates. Now, DNA, okay? They checked for blood, hair, skin, body fluids, right? That's what we're looking for in DNA. Touch DNA, blood, semen, meaning body fluids, okay? Nothing.
But what's important, folks, is all those samples that they sent, the hair, they sent several with asking for comparisons to Paul Hicks, to Walter Beatrice, Mikey Perkins, who's deceased, not at the time, Alan Todd, Brad Jones, Victor Perkins, Eduardo Gonzalez. You know?
Speculation and conjecture. The defense attorney telling this jury and the witness, Steve Gates, well, full immunity. He lied before. You can't believe him. Tell us what you think on social media. I'm going to be checking that to see where you fall on this case while we take a break. When we come back, of course, we're going to get you back in for more of the defense closing argument.
Brutal killings send shockwaves through Hollywood.
Rob Reiner and his wife murdered.
Court TV takes you inside the investigation.
Their own son charged with their murders.
As a community mourns, and a troubled son is now a defendant in a double murder.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special tonight, 8/7 Central on Court TV.
Of course, we'll get you back to court in just a moment, but first, here's a quick look at some of the other cases we are tracking here at Court TV. In Utah, a woman who confessed to murdering her parents and trying to kill her brother is being sentenced today. And in Wisconsin, another sentencing underway for a teen convicted of killing an innocent bystander in his gun's crossfire. And we are standing by in Massachusetts, where a former police officer accused of assaulting a fellow officer while serving her papers for a restraining order is in court next hour. We will keep you updated on all of these trials throughout the day. But for now, let's go back together to Ohio, where we are watching closing arguments in the drowned wife murder trial for Paul Hicks. Right now, the defense continuing its closing argument. Let's go in.
Name is conspicuously missing at all when you go back in the jury room. Steve Gates. Hey, you know what? We got this guy's personal interest. Story's kind of crazy. Well, hey, Mr. Gates, come on in. You don't have a constitutional right to your hair sample or your DNA. We want to take some tests. We want to rule you out. Nope. Okay. No fingerprints. They sent fingerprints requests to the lab. Right? There's also 4 other men that were potential suspects that they didn't send any testing out. And those were some of the people that Regina was intimate with during this time period. And we bring that up again. She's allowed to be with whoever she wants to be with, okay? It's not about trying to
disparage her with what she's doing. She can be with whoever she wants. Paul is. That's maybe a moral concern to some of you, but the fact of the law is she can be with whoever she wants. The significance is those four names besides Mikey Perkins, they didn't check anything with those guys either. To rule out them as potential suspects. To rule out whether or not was it their care in the Camaro. Because we damn well know it's not Paul's. No footprints. No soil samples. No handwriting analysis or weapon linking Paul to these two alleged crime scenes. And again, we're not saying that this first came to law enforcement's light this year. Back in 2001, they were investigating, so it's not like time has withered all this away. And even if it did, your obligation under law would be to hold it against the state, not against the criminal defendant. So I want to talk to you about, like, the boots. I want you to ask yourselves, be intellectually honest with yourselves. They keep talking about these boots. Do they charge him with tampering with evidence? No person knowing that an official proceeding or investigation is in progress is or about to be, or is about to be or likely to be instituted shall do any of the following: alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value. I asked the witness specifically, did you see any footprints around there? Okay. And we know we've got it at this point, and it's not clearly not intentional. They, once they find a body, I think things change, but we don't have that yellow crime scene tape around that car, okay? Because the Whetstones, they're normal people, right? They're pulling I understand the son was a suspect too for a while, but the fact of the matter is on that day, they're like, oh, wow. And then they find what they find, right? So law enforcement, first responders come down, they're walking all over the place, but they said there were no footprints. So I don't understand why they're trying to say his boots are like some kind of indicator that's going to solve some kind of crime. Now, they did soil samples, right? Regina is allegedly at Gates' property. She's there. There's no soil samples that implicate Paul. What attempt did they try to get his clothes? Nothing. All right. Bob Dylan. You don't need a weatherman to know which way the wind blows. Okay. Why this is important? Because I think we talked to Ward here. To be an expert, you don't need to have an advanced degree from an Ivy League school. You can be somebody that barely got out of grade school or third or fourth grade. Let's say if you're a master woodworker or several trades. That's what you do every day, all day, week in and week out, month in and month out, year in and year out. That's what you do. You're an expert. Which is one of the reasons I did challenge, like the first 5. Because that's what they do. They do DNA tests in and out, in and out. Fingerprints, that's what they do all day, every day. Probably boring, that's why you got it. That's why when they come to court, it's interesting for them, I think. And when we talk about experts, most of them, I think, they answered the questions, right? The guy from The Sopranos, Roth, right? The drug guy, another entertaining witness. He's on direct examination.
And this we're going to get into what we call team bias in a little bit and confirmation bias. But on direct examination, they're showing in things up there. It's like, oh, wow, man, I can't look how old it is. Oh my God, wow, look, oh, geez, wow. Then I get up on cross and I say, well, you'd agree with me that, the technology in 2025 is significantly better and more sophisticated than it was in 2001, 2002. Well, now I really wouldn't say that.
I want to take a break there and pause it and welcome my guest for this hour to discuss. Joining us now from Cherry Hill, New Jersey, criminal defense attorney David Gelman. David, great to be on with you. I don't know that I've been on with you before, and I appreciate you joining us. Let me just ask you first how you think the defense attorney is doing in his closing argument right now, currently pointing out the truth that there's been no forensic evidence suggesting that the defendant committed this crime.
Judge, great being on with you. Yeah, first time being here with you. And I think the defense attorney is actually doing a pretty good job overall. Look, it does help that this is a cold case. This has been happening for over 25 years. There's no DNA. There was no witness. There was no, and frankly, the only thing that the prosecutor really has is an individual who has lied in the past saying that Paul was the actual murderer of his wife. So all these things shows one thing: reasonable doubt. Can you find reasonable doubt? And it's beyond that scope that you have to show that this individual was in fact guilty of it. I really do like what the defense attorney is doing. He's showing each juror what is going on and what the prosecutor is not being able to prove. And I think it's a good strategy. I really do. And I'm very curious to see how else he goes about doing all of this, because frankly, the prosecution, I think they do have an uphill battle here. I really do. I know they think they have a strong case because they have somebody who says that they have a confession here. But I got to tell you, the defense, I like where they're going with it.
And you just went right where I wanted to go with it, which is, I know that you worked with the prosecutor's office. Do you think there was any opportunity for there to be a discussion in that prosecutor's office about, do we go ahead and prosecute this cold case on the basis of one witness that we give full immunity to, or do we not feel that that's enough evidence? Clearly, they reached the decision they think that's enough, but do you think there was an opportunity to say maybe one witness isn't enough?
Oh, I could assure you that this was a discussion, and I'm sure they had it a lot. Look, one witness, in my opinion, I don't know if that's going to be enough for this. I really don't. I don't know if they had pressure, though, from high above. And also remember, even though this is a cold case, the media still talked about this case for over the years. So maybe the prosecution and the prosecutor, they said, look, let's put everything on the table and let's see what happens. I'm thinking that's kind of where it went. And, look, if they can get a conviction, great. But if not, I think they probably are saying, look, we tried our hardest. But I don't know if this was the best way to go about it.
And I agree with you. When I was on the bench, I can tell you that there are often cases that sometimes would be, yes, there's enough evidence, so we are acting ethically when we bring this case as the prosecution, but we also recognize we're not certain what a jury's going to do. So we'll put it in front of a jury and let the jury decide, or the judge, if it's a bench trial, decide what decision they're going to make based on the evidence. This is an interesting one. Stand by if you would, please, sir. You're going to stay with us. We're going to take a break. Of course, when we come back, more of those closing arguments from the defense attorney. Stay tuned. Welcome back. You are watching Court TV. I'm Judge Ashley Wilcott, in today for Ted Rollins. Now, we are watching closing arguments in Ohio, but I want to mention something before we go back to that, because there's another case caught in the crossfire murder trial that we've been covering here at Court TV. Wisconsin versus Paris. Larry, you may recall him. He was 16 at the time of the offense. Well, today is his sentencing hearing. However, we're not allowed to bring that sentencing hearing to you until it completes. but I just watched, along with my production team, a kerfuffle in the courtroom. So we know that individuals in the gallery were reading their victim impact statements, making statements to the court. Well, we watched the cameraman watching one of the attorneys making a statement seated at his table, and then you hear the judge say, stop, stop, and the cameraman turns the camera, and all of a sudden someone leaps up, the second person from the end in the last row of the gallery leaps up, and a fight starts in the doorway. Now, there was a deputy there very, very quickly who interceded, but there were a lot of words, some of which was something that will not be televised, yelling, screaming by a young lady, and we don't know what happened. We don't know why this happened, but needless to say, we are going to keep our eyes peeled, and you're going to want to be in that courtroom. Anytime, I can tell you from being on the bench, anytime that happens, the deputies are responsible for getting the judge off the bench to safety, which they did. They also got the defendant out of the courtroom into the holding cell because those other deputies are needed in the courtroom to calm everything down. It looks like they did. We are going to be bringing that to you later here on Court TV. So now we're going to go back to those closing arguments again. This is in Ohio, where a man is facing life in prison if convicted in the cold case murder of his wife. The prosecutors, remember, allege that the defendant, Paul Hicks, knocked his wife, Regina, unconscious before leaving her body in her car and then driving the car into a pond. This case was unsolved for nearly 24 years until Paul was arrested earlier this year because an individual came forward and said, under full immunity deal, I saw him do this. He killed her. This was Steve Gates, one of the witnesses. Right now, we are bringing you closing arguments. We have been listening to the defense's closing argument. He just stopped with, there were no forensics connecting his client, the defendant, to the crime scene. Let's go back in.
Well, now, I really wouldn't say that, because, well, yeah, right. Okay. Apparently, all technology is advanced in every other discipline except the drug analysis. And the point was, some people like their 14 seconds of fame. Then I asked him, real simple, hey, when's the last time you testified as an expert in a criminal case? Well, you gotta understand, Did you understand the question, sir? You're willing to answer the question, even if it's a simple question? 12 years ago. Team bias, confirmation bias. So, besides not testing Steve Gates and the other 4 men these days, they didn't do the one test that they absolutely should have done, or at least explored, or at least tried to do. What is that? Accident reconstruction, okay? They've got the car. Mr. Whetstone graciously allows law enforcement on his property. They didn't do it. So I want to talk to you about your common sense, okay? Sometimes they say, well, common sense ain't so common anymore. And that's kind of what this goes to. You don't need a weatherman to know which way the wind blows. Because you watch TV, I'm sure you watch some of these kind of programs. But let's talk about what an accident reconstructionist would have done in the case. Scene analysis, measure skid marks, debris fields. Now, we know that there was a lot of debris, but it was all in the car and floated to the water. What are the roadway conditions? You use drones, lasers, to show the depth. Vehicle inspection, they did that a lot. But you examine the damage to determine angles and speeds. The only damage that appeared on that car was, I think, like the plastic rubber on the front right corner. Okay? And there's no evidence of how it got there. Was it there 2 days earlier, 3 days earlier, a week earlier? We don't know. Checking brake function, tires, lights, other mechanical systems. And if you can't do that on that 1994 Camaro, there are plenty of other 1994 Camaros around 2001, 2002, and probably they might be higher priced now, but even in 2023, 2024, right? Examine the weight, determine what the weights were of a 1994 Camaro. And the reason that's important is I think it came out, I asked the witness about it, Mr. Wells talked about it, and that is because now we all have black boxes. Some of you might not even know that. In your car, it's almost just like aircraft. They can tell you how fast you're going, how the deacceleration. They can tell you what the weight of the front right passenger is, what the weight of the driver is. They can tell you all kinds of stuff. Why? Because technology has advanced not only since 2001, it's advanced since 1996, and it's advanced since 1994. And so knowing that you don't have that, we got to figure out if this cockamamie story from this Gates guy makes any kind of sense. Physics and mathematics. They took some measurements inside the car and things like that, but how about the calculation of the speed? What is the potential speed of that vehicle going over 30 feet into the water? The momentum, stopping distance. Analyzing point of impact using force vectors. Now, again, I understand it landed on the water, so you're not going to have the words at a fixed place where it runs into a guardrail or something. Totally get it. But the point was, no efforts, no attempted testing. Reconstructing time.
All right, an interesting point. I like that he's picking up on really specific details in witness testimony, that there are plenty of 1994 Camaros around in 2001, and why the jury needs to think about that detail in considering reasonable doubt. Stay tuned. We'll take a break. When we come back, we'll get you back inside court.
Brutal killings send shockwaves through Hollywood.
Rob Reiner and his wife murdered.
Court TV takes you inside the investigation
Their own son charged with their murders.
as a community mourns, and a troubled son is now a defendant in a double murder.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special tonight, 8/7 Central on Court TV.
Back now to Ohio, where we have been watching closing arguments in the murder trial for defendant Paul Hicks. Hicks is charged with 3 counts of murder and 1 count of kidnapping and the death of his wife, Regina. You may recall that her body was found in the passenger seat of her car, submerged in a pond more than 20 years ago. Coincidentally or not, 3 days after Paul filed for divorce. Right now, let's go back in the courtroom together and listen to more of the defense's closing argument.
Reconstructing time and distance. Technology and simulations, we see that all the time, right? They're going to give you a they're going to come in, they're going to give you a computer simulation of what they believe happened based upon their star ear witness and eyewitness. Using AI, modeling lighting, weather conditions. All right. Back in the 70s or 80s, I guess some of you are probably too young for this, but George Carlin had a routine about dirty words. Okay? And we know 4-letter words, right? No. And I submit to you, bias is a terrible 4-letter word, especially in a courtroom and in a criminal case. Okay? We all have our own personal biases, prejudices. It's just what makes us human, okay? But when we're talking about potential professional bias, professional team bias, professional confirmation bias, it's a problem. Confirmation bias is the tendency to look for information that supports rather than rejects one's preconceptions, typically by interpreting evidence to conform to existing beliefs while rejecting or ignoring any conflicting data, okay? We see that. I think we talked a little bit about that in voir dire. That's one of our problems right now, currently in our country, this big political divide, right? Because what do? We shut the other side off, right? And we get tunnel vision, right? And we put ourselves in an echo chamber around family and friends that agree with us or think like us or talk like us or have our certain values, right? And we rule out. We don't want to listen to the other side, right? And we can find any reason not to, right? Whatever the reason might be. But it's problematic in a criminal case. Team or tribal bias leads us to make unconscious choices that favor our team and that disfavor the other team, the alien tribe, the opposition, right? Again, I think we talked about this in voir dire. We used the example of the Ohio State-Michigan football game. The one controversial play, Ohio State fans thinks that's a catch in the end zone. The Michigan fans thinks no. He bobbled the ball, and therefore it should be not a safety, but a change of possession, right? Because that's how we think, right? We're trying to find something that we latch onto to get the result that we want. Okay. Here, where does this come out in this case? On cross-examination, Mike White acknowledged that no polygraph test was administered and that standard testing protocol was therefore not followed. He also agreed, on cross, of course, that false confessions can occur and testified that he could not rule out Hicks' innocence, his outright innocence. He's a career law enforcement officer. Now, State's Exhibit 12 is appropriately captioned Paul Hicks interview. But we know, it was clear in the presentation of evidence, okay, that within the first 35 seconds or so, Paul says, does it matter if you've been drinking? Again, just so you're clear, early on. White, well, we'll go ahead and start the process. Dane, you think? Mr. Howard, yeah, might as well. White, yeah, he's here. Comes in. I missed your name. What is it, Paul? White, Paul, my name is Mike White. Have you ever taken a polygraph examination before? No. Okay. 2 questions down. Does it matter if you've been drinking or not? No. On any kind of pills? Okay. Well, it depends. What type of pills are you taking? What are you taking? Hicks. I think the number 5 Xanax. Took 3 of them. Oh, that's going to be okay. False. And now, they ridiculously want to argue to you that you can consider the fact that he took pills as a consciousness of guilt. He walked in there right and said, hey, listen, I had a couple shots, I took some pills. He wasn't trying to deceive anybody. It is kind of a red herring because what do you know now? You know that the polygraph was a complete ruse, a farce, and a sham. It was an attempt to try to interrogate and intimidate Paul. I need to give them overwhelming evidence. I need
All
them
right,
to...
still with us, criminal defense attorney David Gelman. David, I have to ask you this. I've noticed this defense attorney is weaving throughout his entire closing different references to things that individual jurors may grasp or glob onto. So for instance, where's the beef? We know it's from a commercial. Then he's talking about getting across the goal line, some football references. I think it's a good way to make sure he kind of connects with different jurors, or is it too much and spreading out a lot of different information? What are your thoughts?
No, Judge, I love it. I think it's exactly what you got to do. You want to get personable with the jury. Look, you know how it is when you have a jury. You can't think that they know all the answers. You got to look at them and talk to them like they're just one of your peers, that they don't know anything about the law, that they don't know anything about anything. You just want to make sure that you can resonate with them. And that's exactly what a defense attorney's job is to do. Resonate with the jury, because if you do that, the jury, when they go back in that jury room and they start deliberating, they are going to remember, hey, I like how he talked to me. I like that reference about the beef. I love beef, so where's the beef? Hey, here it is. Perfect example. I've had instances where I've won trials just because I've said something, or how I look. Like some juror said, "Hey, I like your socks." These are different things that happen when when deliberating. So any advantage you can do, I say go for it. And I think he's doing a very good job.
And I love that you brought up about your socks, because we have a guest who was on jury duty and served and was the foreman. And he said he couldn't believe when he got back there what the jurors were talking about in terms of what attorneys were wearing, what the defendant was doing, what the judge was saying. Every little detail of those things the jury takes into account. So just in the last few minutes, is there anything else that if you were defending this case, last few seconds, I'm sorry, you would make sure you hit during closing?
Reasonable doubt. Reasonable doubt. Keep going with that theme. They have all this, they don't have any evidence, and that the only thing they have is an individual who's lied and said that Paul is the one who did it. Just say reasonable doubt all the time, and I think you're going to have a winner.
All right, David Gelman, delightful to be on with you. Thank you so much for your great expertise. Coming up next, more of these closing arguments in the drowned wife murder trial for Paul Hicks. Plus, sentencing is underway for a woman convicted of killing her parents and trying to kill her brother. All that and more after the break on Court TV Live. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. I'm in today for Ted Rollins. We begin this hour in Ohio, where a man is on trial for the death of his wife 24 years ago. Paul Hicks is accused of rendering his wife, Regina Hicks, unconscious before putting her in the passenger seat of her car and driving it into a pond where she drowned. Prosecutors say the couple was separated at the time due to Paul's violent tendencies, and that they were fighting over custody of their child at the time. We want to get you back into court now. The defense making its closing argument.
Mr. Saras, question. Where you thought she was dead. Yeah. I'm not a doctor, but when she's motionless and she's not screaming and she's not fighting. Then on page 73, I asked again, so clear, I asked Mr. Gates specifically, Mr. Berg. Mr. Berg asked, when you saw what you saw, did you ask him, what the hell did you do? The witness, right. Well, he's all... They won't fix it. Jump up a little bit, page 78. Agent Hamburg, was the car in the pond at this point? Witness, completely submerged. It was gone. Now, again, critical part of the case. And it might seem like small, or you glance over, but I respectfully argue to you, it's important, okay? Because they're asking him about the phone calls that Paul made to Regina. Agent Burke, and when you say, and just to clarify, when you say he picks up his phone to call her witness, Regina, Agent Burke, he picks up his phone to call Regina, witness, to leave a nasty message. Where are you at? You're supposed to pick Montana up. That's what he said at the proffer. Mr. Casares, do you know if he called her landline or cell phone? No. Something with an answering machine. Something with a message sent her. Why is that important? Because when he was here live, what did he tell you? That's why you can't trust this guy. He's a charlatan. If lying was an Olympic event, that guy wins the gold, the silver, and the bronze. Then what does he say? We're asking him about fear. What did he say live in front of you people? Well, it was the Hicks family, Regina Hicks family, but he didn't say anything specifically about Paul. No, he says, well, Chad, for one, he talks about Chad driving him off the road or trying to hit him head on. And the purpose of that wasn't to try to say that the Road family did something crazily wrong. I was trying to emphasize that he's saying stuff about Paul without any specifics whatsoever. He was very specific about the Chad Rowe. You know what? Chad Rowe thinks you killed his sister. You, Gates, maybe that's why he tried to drive you off the road. Your story doesn't make any sense. They can't rule out that you were the sole actor, the lone actor, drove the car into the pond. They can't rule it out. And, oh yeah, they didn't send any of your DNA to be analyzed, or fingerprints, or hair, or body fluids. Page 115, once again. The interview's coming to an end. Mr. Casares, anything else? Agent Braunschweiger, I'm good. The witness. So basically it's like the interview's over, right? Proffer's over. Gates, I'll tell you anything. Next page, 116. Question. Since we reopened the questioning, anything else that you remember that you think we should know about you or Paul Hicks? Answer. I mean, I'll tell you anything. At this point, I'll tell you anything you want to know. Page 117. Casares. Mr. Casares says she's dead. Gates is up in bed. And he told me that. So, submit to you that you can't kidnap a dead body if you believe this crazy story even to begin with, even by their own evidence. Mr. Casares, at the end of page 133, we'll get to the end of this. You didn't see anything physical between Paul and Regina. So you got busy and did something else. Answer, yes, I never saw him touch her or her touch him. Definitely yelling and screaming. So the state just wants you to believe, through speculation and conjecture, that a serious assault took place. Okay? And this goes back to why it's important to go back to Dr. Bartlett. If you want to purposely try to kill somebody, I mean, you stomp on their head. I mean, you break their skull. You have broken facial bones. I mean, if that's your intent, if you're purposely trying to kill somebody, and that's assuming that you believe Gates at all. Well, the witness that says I like. Let me ask you something. Do you realize now that you put a wire on the potential sole murder, the murder of Regina Hicks? Because when they put that wire on him, folks, they had no idea he was lying through his teeth to them. They had no idea. And I said to the witness, well, you know, he lied. We know he lied on or about October 22nd, 23rd of 2001. Yeah, we know that now. And he lied after that, and he continued to lie. It's baseball, but you know, the problem is this is not a game. It's not a game. What did he concede? Another career law enforcement guy. We got duped. Yep. Yet the government is asking me to take a huge leap of faith in a witness who they have acknowledged was lied for 25 years. And then I think they thought, well, during his proffer, okay, this is what we got to roll with this. It's the best we got. We got to roll with this, right? It's an adversarial system. We're trying to solve this case. It's been a long time. Hey, we got to roll with this guy. So even though he's the potential killer, even though we didn't check his DNA, we didn't do anything to rule him out as the killer of Regina Hicks. Let's roll with it. Let's roll with it. So just going to tell you, the offense of reckless homicide is distinguished from murder by the absence or failure to prove that the defendant acted with the purpose to cause the death of Regina Hicks. Again, there's no evidence of this. There's no credible evidence that this even took place. Certainly, zero corroborating scientific evidence. When we talk proof beyond a reasonable doubt, it's of such character that an ordinary person, that's most of us, I think we're ordinary, would be willing to rely and act upon it in the most important of his or her own affairs. So what are the most important decisions people make in their lives? Well, let me ask you this. Let's say if your child or your grandchild had a serious medical condition, would you buy what Steve Gates is telling you? Absolutely not, because you already know he's a charlatan. It was not kind of weird. I asked him, "You ever drink milk?" No, I don't drink milk. Well, did you ever have a stale beer? No, I don't drink beer. Well, I'm going to tell you what. You don't have. You can attempt to drink it for him, right? And as you damn well know, based upon your experience with human beings, that you go to have a sip of milk and it's spoiled. You don't drink the rest. Well, that's the same thing with the government informant. He's had 25 years to be truthful with law enforcement. And I think and that's their business.
All right, let's bring in our guest for this hour. Joining us now is Philip Dubé. Thank you so much, Philip, for being on with us. I always appreciate your expertise. I'm in for Ted today. Tell me overall, the one thing that really stands out to me about this defense attorney's closing is that he is going through every detail. The fact there was no forensic evidence linking his client to the crime. The fact that the person, Steve Gates, who testified and said, "Oh, I saw him do it, it was me," was under a full immunity agreement and had lied before. What do you think of this closing and the case?
I got to tell you, I'm not impressed. I think the prosecution's case is pretty strong. You know, Ashley, in the old days, before we really had this hella amount of digital and forensic type evidence, be it by way of cellular data, internet posts, who knows what else, maybe video type footage, We relied on direct evidence, meaning percipient witnesses who saw everything go down, and it's up to a jury to decide if they believe the witnesses. Well, here, what do you have? You have Mr. Gates coming in to say he was basically there, and he saw him basically submerge her to the bottom of the lake. I mean, that is an actual percipient witness providing direct evidence. Now, do you need that memorialized on a video? In the old days, no. Jurors tend to be a little skeptical where all you really have is testimony without anything to corroborate it, particularly when the witness is getting immunized. The question becomes, what is he getting immunized from? Why did he even need immunity? Was he in on it somehow? Did he have something to do with this death? What type of sort of clout rage is he trying to exact from coming forward? What's in it for him? Why all of a sudden, after all these years, does he need to clear his conscience? And that's for a jury to decide. But there are problems with the defense case because of that. And then you have his sister coming in to testify that she found while he was living with her, that the bathtub was full of muddy clothing. I mean, most people who have dirty wash, they throw it in the washing machine. Maybe they go to a public laundromat. But why would you, out of nowhere, suddenly have muddy clothing in a bathtub? So that is some pretty, not just direct, but some pretty compelling circumstantial evidence that he was at or near that pond or lake. I think that's very, very damning. And I don't know how you ever overcome that.
And this is coming from you as a former deputy public defender. And so you're accustomed to defending these cases, and you see this as the prosecution's done a good job. How much does the motive make a difference in this case? You and I have talked about, of course, the motive is not an element that has to be proven, but a jury always wants to know why. And in this case, divorce, child custody, does that help strengthen or not the prosecution's case?
Those are the classic motives. Otherwise, why else would somebody do this? Typically, it's because there's another love interest, money is involved, maybe drugs, or a custody battle. And this falls within those 4 check boxes. So they're classic. And I think any reasonable jury can relate with that. Or to that, and not want to lose their kids because of a prior love interest with someone. So you're going to do whatever you can to preserve the parent-child relationship. Now, the average juror wouldn't kill over that. Instead, you go through process. You litigate your right to custody and visitation of your own kid by showing either you're equally fit to co-parent or that you're more fit to have full joint legal custody over the child. But sometimes we kind of lose our minds and we don't want to share custody with a former significant other. And what do? You go to the criminal side of things to get the job done. And in this particular case, it's pretty compelling what they have only because of the direct percipient witnesses that they're putting on. They're not relying on forensics, really.
And, you know, divorce, you're right. A tale as old as time that's a motive. But again, you know, get divorced. Don't kill the person. We'll see what the jury does in this case. Bill, by now, I see you shaking your head, but it's unbelievable to me the lengths to which some people go.